abusanfo yamakwaba ediba dazi TV so jidi se de biam ye interview na ye de brofo na twi na fante wa ye defra but na de obi na kana shima nko na ma ba medim atasa nti mpakwa me ba bedin komo yi our friend lawyer Bernard Kofi Assibuah all ye juma wo eja simani legal consult very legal brain me did the central for media guys are often more court high court supreme court the face is not familiar to it's not new to you, as I say. He's defending one of the big cases in Ghana here, which I'm not going to say it here, but I know that those of you go to court. Muhundi face there, he's one of the big legal brains here in Ghana. Oye Juma, wo Assibuah, Eja Esmani legal consult. As I say, Mamu Bodini, Microfantin, what I'm making sure Bodini, as I say. Oye Juma, I don't know whether he's a lead counsel or the manager partner. I don't really know. You guys will get to know.
I'm just a junior here.
Yeah, junior here. So I'm sure that we have other people here too. And see, today, we have lawyer Bernard Kofi Assibuah from Eja Semani Legal Consult. You all know Ishwa Ababonti and Sabri Ubiani to Hunkomon, and he has read the judgment. He said, I'm just coming to have a short conversation with him now. Sanabaya Ghana phone 1 at 7 one so what you understanding from the legal perspective. Now, essentially, you had that judgment in Kakra. Lawyer, I'm who done sweats in there.
I'm just from court. He's an if you court bear I'm only granting this interview. Your conversation we are going to have. From the Epede Yakasa, a war judgment, that the Lumba ni case no. I obliged because I'm free or there is some legal education.
Yeah.
Na mankasa so my opinion on the matter. Ebisam no, I wanted to let it be clear to the public. Inti, that is it. Inti nyamisha bebre.
Inti, before I go ahead and the moment I judge or the ruling body, everybody's entitled to express an opinion.
Yes.
Okay.
That's true.
In this judgment in my Ankanenkasa.
Oh, it's not about that. Mostly, we would not want to be prejudicial.
Okay.
We would not want to prejudice. Yempede yebeka asama judge the judge watsna asamado ono the judgment bano. It would be a contempt of the court. Say yebe bua sam no asana judge the masam apa. So the judge net sam no mini ho.
Yeah.
Again, I wasn't part of the case. Inti moon to me preempt any decision of the court. But judgment in the barrier, you told me kamasama or onu crampono, we have a limit as lawyers. We have to comply with our rules.
Any opportunity, first-hand information, at least, and you read the judgment, and I'm sure the brother started trial, and at least one way or the other, and you may have maybe read the kakra, the cross-examination, and who other. Nobody tough. Otembuaf no patcher then.
A judgment na makana. Ubia dena some kokota or expect a certain result. Inti ye mame Akosua Serwaa no dena some kokot.
Yeah.
The ye nuya ye papa dadulumba na we fimono. Court no Mbua say the only surviving wife to Daddy Lumba. Now as a surviving wife, court no so on Kade, she is the only person that what we call widowhood rights is done in a customary way. Again, yen mame no pede court no boade. Opinion ane ebusu opinion oda dadulumba ne ebusia no nano no Kofi Usu
ono na our friend to pack
mempede my friend
to pack
oye nipa penyin ye de woman
my friend am you okay also do Ghana for this very
one ajatu but me as a lawyer no mepede me use the right names
okay
enti yen papa Kofi Usu mama onhu yen mami yen nuya yen sister Odo Broni as a surviving spouse of the late Lumba. na osanso injante osanso keche court in there court in restrain ejuma kese a wo from one if there was a
funeral committee
no funeral home
transition home.
Yeah, the court should not allow them to perform the program, the funeral program. Inti ordinary assembly or the court. Now, on ordinary assembly court no. Yen sister Odo Broni so the nasam the court. On also your friend counterclaim. No so the court. They also uji the daddy lumba yeden or no. Na daddy lumba were no so also or who kind of bed or be performing funeral right widowhood rights. And also the nasam the court. Na yen kombre ni nyina no judge no otena asam no do no or the nano di nana asam de or the buy. Na asam no the buy no oye wanwa the asam a ye mami Akosua Serwaa the court. We call it reliefs claims. A kumpo ni wa judge no court ni di man. A kumpo ni wa court no e di man. Na judgment no my first comment nene say protocol say because is very resounding. The judgment was detailed and yet technical. Very informative, educative. Awumpo a said enye lawyer ni enye judge na can judgment no easily follow judgment na judgment na.
To use more of technicalities here, the wording of the judgment now there.
No, yeka technicalities are law is a language. You need to understand the language. Now judgment, when you see yen Mami Dorinda Smith, when use one far.
I'm sure about fancy.
Well,
Dorinda Smith that
but one far technical word. Yen lawyers words are you use jargons are we use our judgment.
Okay,
one friend and fan true judgment. And some more children or yeah, some more the whole piffy ubia kana otase. Normal people, ordinary people, reasonable people, they can read the judgment and understand. And it is again informative and educative. Our enwarida eti awarase ewo judgment no.
Okay.
Ubia wa warrior na wanu nkoyi ote. Enyama oyedo kodo ewa awarim otase. Then customary marriage sebi obi wo wa oni boyfriend girlfriend atena infe bebre onkoye no ade e can judgment na ehu wodi bia wo awarenum whether you are married or not. Inti judgment no emu da ho. It's a good judgment and very resounding. Inti that's my initial comment. I've read the judgment. It's about 49 pages. Ekana etase and it's good, very detailed. And with all the information in it, yeah, mami ordinary some court, a kumpo in your reliefs kumpo in your nesaka. On no
right now, we release I'm a public now, be reading, 47 or 49 pages, I guess, but on Ankasani statement, and before we read the judgment, can 74 pages.
Okay.
Until lawyers no call the certified copies of the judgment, 74 pages, which means over 30 pages be over. As I speak to everybody that's passing comment in the couldn't read it, unless you also have the 74, which I'm sure other lawyers are having it. Okay. I'll finish you with the full judgment, the 74 pages, so that you have a first-hand information.
That's fine. That's fine.
Then, right now, judgment in the bed will be at the Chanadin.
Okay.
This is the 1 year, this is the 1 year, this is 1 year. This is the lawyer phone, why disappointed, Akosua Serwaa, this is the Banida. Release the other court, Dema, again. All the reliefs Akosua Serwaa one grant even not even a one. Into one case show me. What do you think was the loopholes and intimate judgment in Okan there? First of all, Mr. Fumini Uncle Kudikuna.
Today, my mechanic, yeah, my men ordinary some court.
Yeah.
At the was some court, you have to come with evidence.
Okay.
Into me for what some court, the master map, one come from one from come or there at the evidence at the court. Evidence na at the bokono. It should be legally accepted. On here, evidence biya na ebutum da court. Evidence edible court. It should be admissible or there court no jitum. One, them evidence here that be obetumi aboa ma wasam na ye ba beti no wabo. Eno ye one. Two, evidence fi one ma witnesses for na anyone bokwan. One na wo ko gina medi wabo ma aka wasam no. They should be credible enough. Or there what can sama sebi oboto court na dream. Na court mbejina do ni we wasam na mo. Say amfa evidence oya credible. Amfa witnesses are were credible. Amfa nkwa court ni ndi wasam mo. Onya sembia na ediba court edi ebeka de evidence bia roko. Evidence no po ede kwa akoma court na dream wa kan wasam mo. It should be accepted by the court. It should be admissible. It should be admitted by the court. Into every evidence now, when you pay for the the evidence now, edakon obobo. Say evidence no ambo, witnesses no ambo, muda wasam no court rindimo. It's a straightforward thing. Into them case here wabe, eshe judgment no ma, there was problem with the evidence. One, ye pede. Mama Akosua Serwaa pede court no kade she is the only surviving spouse of Daddy Lumba. And you know, widowhood rights should be left with her. Essential evidence we are looking for is marriage certificate, because telling the court to say you are the only surviving spouse in each other, you married under monogamous marriage. There are 3 forms of marriages that are accepted by our laws. We have the monogamous, that is the ordinance marriage. On a one man, one wife, or one woman. Then we have the Islamic marriage. Then also we have the customary law marriage. Ono customary law marriage, ono ne ye bema ewera ebutum afa awer imbesiafo ebien ibasa and an account, depending on your financial resources and financial strength.
Okay.
Nti asamna Mama Akosua Serwaa de no patche de. She is the only surviving spouse. Meaning that Daddy Lumba married her under the ordinance. Now, ordinance so is governed by laws. Our ordinance, monogamous marriage, is governed by laws. Inti embranwa ote hono chede or edenya what we call marriage certificate. Now, actually judgment no ma ye mami Akosua Serwaa kade. Onye Daddy Lumba were civil law marriage ewo Germany.
Yeah.
Civil law marriage with Germany is the same as Ghana ordinance marriage, Until say here the say or the certificate should be evidential. Not the civil law marriage na year Germany. Also a day in certificate. But 18 Mamekana or day in your certificate. Until say in your certificate, na say Eba Ghana they won't declare as the only surviving spouse. Onye ye. Ono onye ye. Na certificate no so say edifi amana ne edeba no so embrete ho. Onye de certificate no ewon wo Germany ane ewer wo Germany mo one more certificate on inti edeba edaba magana court de multi Ghana court ye juntum wonye ne dem. No so embra etem. Embra tem ho no ma kwan say obiade certificate a credible or baba Ghana court say and fact credible certificate and found back court no only was some more na yatin some bebre fa authentication your friends
you be here ho education process na dey
can processes in bebre na judgment so court no my direction the court provided judgment on that how the certification or the authentication should have been done. Okay. That should be the process. Yama me aba court the one dina some man or the nankasa ni reliefs happen. No here do the nankasa ni evidence. Proof. You have to prove it. Say evidence would have a nature there. Yen Papa Daddy Lumba or wherever civil law marriage. That I don't say or only adanse no so amedaba no so Ghana ajatum Germany in Brussels ajatum then the court would admit it witnesses are anyone abano or the work can sama of a queen na obo wasam na eden edaba court on the witnesses no wabana wabaka asembia na we free day waka senti na anyen there be until them because otambua for the judge ono otena so omunya asam obiara ka evidence obiara de aba na wahwe ho na wayede odi boatem inti them asemia wabe be free the baby auto chill kakra the evidence na some witnesses na nkasa working ono no mama Akosua na asam no wankwayi aman they say you only film so there could be other factors but fundamentally it was about the evidence and what the witnesses said in court.
The witnesses now can only the witnesses for the respondent but for the plaintiff.
For the plaintiff one now mama
that is Ernestina mama Ernestina Fosu and
Georgina and some are came on na judge no ohu loopholes gaps no or the buatan or the my judgment and then some insido because actually from a cross examination and some are working no one anka some are working one witness statement no insido
and cross examination na witness statement now to was submit witness statement in the first
asana cross examination into witness statement in here asam no witness no onyim fa asam no on na double court into double court no respondent no lawyers no they will cross examine you on that and asama will be so asama wankasa atro no into say asama awa atro na asama awa abaka wo court no obwebra Emma court and can was some more. So some one can say aka or court, to people that are court. So we insist no will be someone some more court into Mancania. It can't help you.
There was a part be our can there. One casa that is Georgina. I'll be Jinama Akosua Serwaa. No witness statement of patch the contractee alone.
For instance, will to manka loan
amount will be son. Ada wan kasa atro na afa abegina de ka obi sa wo sa tumanka
inti bibi dem na ye pache as wan kasa se mama Akosua Serwaa na dad no ba kwaji loan na mo kwaje ye no court bi sa ode loan ahe na waje intumanka waje fi aba bank intumanka loan no se wetua ahe na wetua ahe na waka intumanka inti se intumanka denti na court edo oje asama wan kasa ida aba court abotro denti na pede court ni jitum court ni rinjintu on your damn work. Court I've said is a language. You have to understand the language. And sana, you can be in court. Your kokota, brofu na today yerka, but on your brofu keke. It's a language. Into language in tum and express na kan wo quarter. Into judge no undim fam.
Okay.
But today sisi abet na he na make a Chinese. Mentasi
intinya damutum.
Ebetum aka ba samo intum nkan hwe wo. Inti asama wanka say da bakotum na ye bi so asam
na some part bi so we send what your letter about the intention to but all initiate process no period ja ware and so will be some witness no ma response other man you completely different from what
exactly.
Was yes
exactly no chada nanka sample asama letter no kan wasampo no onyim ho asam bia but order to paper that about court.
So in this situation in case there say evidence no the ban ojinai naka witnesses in one bar. Which one will override the other?
We are talking about evidence.
Evidence.
Yes. Because evidence, me feel there, me my dream, ohia pa.
Yeah.
Witnesses, because one kasa was some idea as evidential, ono no bobo was some namo.
So in this case, for instance, maybe today, Kawaji, marriage certificate as the evidence in what G to accept here, and Kabianka witness statement now, then the crown on shed and a big huge
witness to determine no it's also important. All of them are important. In marriage certificate na ba no ye baby so wansam why no mo sign here e ba Ghana hanoma e for marriage certificate the parties sign, that is the man and the woman, the husband and wife will sign. Yes, then the witnesses will also sign. Into the marriage certificate diffi Germany deba na say parties no aware for no one sign no before for na wa sign a abɛde na ɔkyɛ dɛ a marriage certificate. It cannot be a marriage certificate.
Be a watch row there within their jurisdiction, a be a one
until them.
Until I don't know why no one make sure there the mad will timwa for no or tassy there.
In authentication, any year one.
Okay.
And now in plaintiff no ne counsel no so in chobotum de expert witness if he Germany or the aba na we be di adanse wo kraten na whether aba as evidential no be di adanse wo but ye hu bibi dem and in the judgment the judge said it then at least enjoy there counsel for plaintiff no or the expert witness or the then or the Germany and a German embassy no be the adanse they won no they not because Ghana they no ye different ye na judge no we to my then wajatu.
Indeed, that comes to the law of evidence. Evidence Act now working on section 161 clause 123. What's all 123 bia? And fire from kakra. Because the whole judgment the biana mechanic the trump card for Akosua Serwaa was the marriage certificate. The marriage certificate didn't go through and come there. The judge will not even struggle to probably because if I've determined that if I can any other thing can be an ABI, it could be part of the judgment though, but the weight of evidence and original marriage certificate.
Okay, intino. This is the point. Monogamous marriage must be proven by documentary evidence.
Okay.
Osande Erica de Osimosi wawerem no. Abaya ajatum the wawerem. Kate yaka documenta. You are talking about kata or the adanse de nipakuna iden wawerem. Inti oware wahin oware wa Germany. Inti Germany krata o de adanse de wawerem no owahin fa krata ni documentary. Ansa na court no beje dem krata na atum. Court ne say entumi mfa krata mfi amanamane enfamba dema enfamba de yenjintum.
Okay.
Ansa na de baba no ado e de ye ne de. Enya krata no it should be notarized. What it means is that the marriage registrar now over German by the Osili, he or she has to seal it or stamp it or authenticate it. Only in area na edako Ghana embassy no over German no also they would seal it, stamp it or authenticate it. One way area now it can be admissible in our court that cartel no America they were udi adanse with Germany but the Akko Ghana embassy because when we talk of an embassy of a country in a particular country it only demonstrates the presence of that country in that particular country.
Yeah.
Inti Ghana embassy now or need the adanse there or you no kware there adanse di cartel na mama say wadaba no of a court registry ewa ha and a marriage registry ewa ha Germany ha and intino court or Ghana here na ye embassy na one you represent Ghana or Germany ya jatu inti ya jatu no court bia or Ghana obotum we use that is what it means simply put.
Okay.
Inti say yentum mama Akosua ne lawyers wentum amfa them processing them. Now what the carta and the court it cannot be accepted by the court.
Okay.
That is what it means. And although ya futu a manya ya were wa amanene. Debi ebia mention them nenyasam. Our were US, Canada, Germany. Baby, it can even be Nigeria. Our were UK. Na awo na wukun we nyasam. Na say edi adansi die bi edere bagana na edabra Ghana court it should be authenticated before Ghanaian courts before court ewo Ghana hanu wajatu sayenda ma de court no ontumenje wakata no ontumonye
Is there any extreme cases where the timing and the speed of the trials and but maybe a mutumu akende or this certificate no the back the respondent or object anka otemboafo no mutumu agya tum dama.
Okay. There could be cases.
Okay.
One of the instances, and then I'm free there, say, counsel for plaintiff, all process them authentication as some a year came. Na so nchu here timer, we here mbra. Which I do too, will be support. With practice, mostly both defense and plaintiff, defendants, the plaintiff, like court, we agree on timing of the case. Inti no we hear pa there, same bring new inche counsel for the plaintiff or J Sakrateno to ensure that process. No we hear bra. All that he could have done was to ask from the court. Sunday, without that authentication, the court will not accept that evidence, will not admit that evidence. It goes into the principle of admissibility. All that counsel needed was to ask for time. Now,
but tomorrow for no share the time there 25th my judgment into 1 year trial before best start or not of fixed dates for the time or be pronounced the judgment.
The counsel for the plaintiff could have asked for time. Me free the interest still I'll go to me, I impress on the court and even inform the court about the processes involved to get the necessary document, the necessary evidence. And having done that, if we then judge no better say and the court and better say again, say or they let tempo the German embassy by the Osimosi and the council apply for this evidence, but we will need this number of months, this number of days or weeks to get them to the court. If we then check, honestly be juma. But them one banner them into court my judgment on the day that it was faced. But if there's a council beside Mbra in Chobenya. Because sometimes we lawyers you be some brief court. Oh, my lord, may 1 month, may 2 months, mommy 3 weeks, mommy day, me 2 months. And the court would have listened to him. Because at the end of the day, we want to what one answer about court. Until you made the master about court, me did the right evidence, me the abrewa. Why wouldn't you give me that opportunity? Even though the court has given a certain time frame, in the interest of justice, the court would have allowed it. But I don't think that was done.
Okay. Now, the contentious part now, or marriage certificate in Ankasa. I read the judgment now. To more from the part there. Ma was submitted what Ben
on an extract.
Was an extract.
Okay.
But not marriage certificate.
Okay.
And I was there was something about quarter. So I have to prove today the reason why I'm missing there for them relief now make can't farmer.
Okay.
So far as now you have other defendants also by responding also by catch there as one they can hear the so now nobody the man or team no better than the also today ma judgment in marriage certificate now I'm not for a patch there even though plaintiff one fat with expert witness and farmer no also patch there the court sometimes also duty bound to make sure the ABR at the be on tasa or not to adding why a further explanation especially marriage certificate or no patch there I thought the marriage certificate extract but right now after the judgment all over the world especially those who are living in Germany everybody for that specific pronouncement from the judge in patch that no say when you are doing it because that's how it is in Germany. Okay. In Serbia Ghana hand say part of the exhibit whatever and the impetu original war sign. I mean she said it in the judgment today. Signatories to the certificates in craft more than one.
Yes.
Now which they presume that if there's no further explanation, we presume that the marriage certificate in Germany is the same as what the one in Ghana here. Which means that in one Ghana here, no, be no be sign, be sign. But what is presented no, it's not like that.
Okay.
And the court also, even though say be a plentiful one fact expert with your children there Germany ko ha one more marriage certificate in the yeah there only the registrar no be sign but the official certificate na dey or record book mu na dey inta wo mo ne ba ha bo no what the family book no da ma o da ba and otemba phone wa admit them also so far as them signatures in count dey or presume there's not something like that
me no question ni ma me hu wa judgment no mo nyede de otemba phone na say
okay
two documents plaintiff counsel what the ban they were different
okay
them not came with judgment no and because they were different no one jantum and you one you also made mention there I'm claiming this relief.
Okay.
Remember that Edwa Samaba, but you don't give judgment.
Okay.
Edwa Samaba, but I don't see or Okanwa or de come with the button. Na ye kanwa sam on ye on the bay. Chidedi ono edaba. Inti it all boils down to the right document, credible document. Edibai. I don't see Edibay, is it credible? Now it also talks about the judgments also looked at conflict of laws. Conflict of laws, the Ghana Embra ewo marriage asema ye kanwe.
Yeah.
They might not be the same as that of
Germany.
Intine ye here expert witness. Ma wabana wabed kanwasam wabedi adansi. Inti there was an expert witness for the customary side. Yema obi wo
Safu Kantanka. Teacher Safu.
Very good. Ashanti obedi. Into the same way, I won't do some about the were Germany. So we were Germany that Ghana and Brano na Germany in Brano on here the same. For expert witness Fabra number kamasam. In 2 man fan bar, the court presumes that the laws day
is the same as the one here. Okay.
In Brandon, it's a principle of presumption. For expert witness, no, amba mwamba kawasama. The court will consider it, say, laws no one, civil law marriage no one, onana. Yet, so no anna, ye de shada kawasam wahadia, no nembrano wahanum will govern it. And that is law. The law is a language. It's not the normal language, it's a today English language, Tree language. Law is a different language altogether, and you need to understand. Men sorry there court. Te embra opeta and your ma court could be some. Bisanwasa. No one show what show more erokwa nedako. Onona obamo obekawasam odamo. The last point I'll make on this point is a marriage certificate. What's a marriage certificate, Fabra? Ebasha judge, the judge notified counsel for the plaintiff during the interlocutory application.
Yeah.
Interlocutory application, the judge mentioned it that this marriage certificate will not work, will not fly here. It was in the judgment. Intimi Freedom at that time, the counsel for the plaintiff should have taken a cue from it. That there was a gap. There was a lapse there. Inti akwaye application the same evidence judge na kanwasam. Then when we are trying the case to you bring the same thing. You've already given the judge an impression that you don't have what she is asking for. That was what I saw. Because the judge was emphatic there. Say, okay, during that application, say, we will not fly, will not be admissible here. Then, during the substantive matter, you bring it.
Turning to also requested for the original, because that was a photocopy. What was a photocopy?
Whether it is photocopy or not, the point is, was it authenticated? It wasn't. If it wasn't authenticated, the right thing should have been done. Nothing more, nothing less.
Okay. And see, when I today okay, which means the previous one of the corner catching the for original certificate in Fambra. Until me patch the maybe said original certificate na year can to one hour when German original certificate now work can. What's in there? damn family book now or the ben. That is one no no what the mobia as a certificate. That's within the jurisdiction.
I agree. My main trial one. On the word mobia.
Yeah, and see that is the original.
But for it to be admissible in our courts, it should be authenticated. It wasn't done. Okay. Afa transport, there are Kumasi.
Yeah.
Na efa car, the same car there. Na car ne fata kradi roader, ebeko Kumasa.
Yeah, I'm saying
them not.
So in the Law of Evidence Act now, in what extreme cases would the court will sometimes admit, take us through the 3 steps in 161 clause 1, 2, and 3. Especially the 3 part, because me tell lawyer no part there looking at the circumstance and the timing, timeline or setting. He felt like with the team, no, even though we have the clause 1 and 2, the 3rd part, the judge could have also explore the 3rd part.
Let me get my. I don't have my.
Okay.
My main share judge so that I do not misinform the public. I would appreciate it. Some evidence acting waha. Nenche. Marshal Mamo.
Okay. For sir, all hear me any lawyer Bernard Kofi Assibuah and Edin Komono. Me bisan say Law of Evidence Act no. Sabri and no na man for air can asem no. You want the clauses, clause 1, 2, and 3. And it is judge, you know, using the discretion or you be come did say the 3rd part, you know, looking at the timing of the case, you know, anyhow, not yes, possible as no. Could the judge you know keep bit me? I explore the 3rd part to make sure say because right now marriage certificate, you know, for what we know is that's original marriage certificate. But then authentication no can. And looking at authentication, that's the 3 part of the Evidence Act.
My member one for Evidence Act and Bremi.
Okay, man has moved to my Google.
Okay.
My main Google, I mean, share the Evidence Act. Law of Evidence, yeah. What can they? Law of Evidence in Ghana.
Okay, so I have it here. Let me read it now.
Okay.
Yeah, and discuss them. Section 161.
Section 161.
Yes. Foreign official signatures.
Okay.
One is also a signature is presumed to be genuine and authorized if it purports to be the signature affixed in his official capacity of an official of an international public entity or a state or a public entity in a state recognized by Ghana, and the writing to which the signature is affixed is accompanied by a certification of the genuineness of the signature and official position of the person who executed the writing. Now, this session is talking about the fact that the document fee foreign states Ederba Ghana official person obia embra genitum de onene obia obotum watcher de documenta eder kogani or your documenta Germany ye diamond
into I made I show you something right now. Does it the corresponded letter nina we na embassy ina windows na dinina there was something like that?
No. This way no was not in evidence, was not adduced to the court or before the court. Near Medichem on CBI. It wasn't part of what the plaintiff counsel used in court. We are talking about this judgment. Are there what they call court? Masisi Edichemi, Mimu official stamp. Ewodo.
That's what they now the court.
Debbie. I mean, my judgment in the kind.
The kind of okay. You are just commenting on the judgment.
Yes.
Okay.
my judgment in a kind of I want to limit myself to it. CCR made that cheer me. I see official stamp on it, but no question in the day. Me who
the Wakawa judgment.
That is the truth.
Okay.
But my oracle, we need a recognized person to endorse it, to certify it.
Okay.
And sign a document, we can admit it in our court. Two, no say, such certification must be signed and sealed by a diplomatic agent of Ghana or of a Commonwealth country who is assigned or accredited to that country. Since some no see what Ghana. Ghana has an embassy in Germany. Okay. Into Ghana embassy in Germany, them official person or today marriage registrar our Germany was certify area at Boko Ghana embassy. Now Ghana embassy no one so why then once we seal what it means is that it will be stamped or the person, the consular there will sign it. Are you getting what I'm saying?
Okay.
Then the third one, if reasonable opportunity has been given to all parties to investigate the authenticity, very important, of a foreign official signature, the court may, for good cause shown, order that it be treated as presumptively authentic without a certification.
Okay.
What this means is that when all the parties have agreed that this should be the procedure, when we have all agreed that this is the procedure, then the court will admit it for the thing having been certified and authenticated. In this particular instance, plaintiff for the defendant opposed it, objected to the admissibility of that document.
Even no more objecting.
Because it was not authenticated. It is as simple as ABCD. So where the counsel for the defendant have already opposed it, and the court has admitted or accepted what counsel has said, counsel for the plaintiff should have done the right thing. They should have ensured that.
But I think I have, because the family book, that authentication part, there was a stamp. I have
talking about marriage certificate.
So now the problem here is that
it is an extract. It is not a marriage certificate.
The court is saying that it's an extract because at that time, courts know in the marriage certificate form in Germany, that is, although it's an extract, it's not a certificate.
Because that is why you have to come and prove your case. You see, this is a civil matter, and it is on the preponderance of
probabilities.
You have to adduce evidence that have heavy value. Let me put it that way. Evidence that are probable, that can convince the court. The evidence that because you have brought it, so you have to prove your case. Into asama ediabano, no evidence na ediabano, or the court no, or then ojitum based on the law. Mama can it should be based on the law. Court no kade because there was some ba epede ye di wasam no mo nti chenche court obi alu ntumfa obi ade na asem bia be court. But Edward Samaba no evidence or there ada eda ba court ni yendi mo no ode de no evidence edeton asama eba ma court e da mo no ode no evidence edeba. In this particular case, I don't think that the evidence that was brought were credible. Enunti na court no anjantum no. Inti yenimembra oyede yebumbra ye mambra no oyedwuma. Mama connect masa. Inti that is it. Into section 161, 1, 2, and 3. Na section a document in the German it should be certified by somebody with.
So now everything you go through by the third party, when the two parties.
Yes, there should be an agreement.
Here, because I was saying that because the other party knew that should the marriage certificate go through, probably that because it's civil marriage. When
it was objected on legal grounds.
Legal grounds.
That is the Evidence Act. And then the marriage certificate or assumed marriage certificate na yede was objected on legal grounds, and the court accepted it. Inti counsel for plaintiff should have done the right thing from the beginning.
But don't you think that sometimes it's the right thing, but because of the matter, the Bible lose another or win, they'll still or want to object it.
No, it's not about that. Ereba quarter. Eba court it was some amount. Interfere in Pacrona, our epeda court was some itiano. Also, Mamma Cash, Umbra no better. Also, by Pen Brown, also by Quatio, because I wear them brand a deba. And brand by Mayaka. It must my Pen Brown, Muslim Boquatio. Mama can it myself. Into another objective because of pedo objective. Also, or defending the client. About and also the brand not be defending the client.
About the marriage certificates in American dam certification added. Say extracts now what the coin. Dam process na nikani na and say it read the way na. You see that there was a transcribed na na was certified languages na na okahu. But here the issue here talking about in the marriage certificate nankasa or work on. Judge no or patch there. More the ban extract on your marriage certificate nankasa.
And so that is what the court found out. That was what the court. And the judge was even saying
because judge no knew that damn marriage certificate in German damn not it.
That is why you would you should have brought an expert witness to come and testify before the court.
But the court also duty bound to also do that.
It is not always so.
But looking at the magnitude of this case, don't you think that it's a court of the because the Biamekande, for instance, there was cross-examination. Let me chip in this. There was a cross-examination from the plaintiff. Remember that in their witness statement of the first respondent and the second respondent, first respondent was Abushapeni. Abushapeni patched there. The second respondent was Prince-La. Prince was there. That was engagement. There was no media, they used the word media coverage. The media coverage here could be picture, video, anything else.
Odo Broni didn't go to court that
yes.
The only
surviving spouse.
She did.
Yes, but remember,
it was customary law marriage.
Because of we can't
me too.
But then Abushapeni ono no evidence about sure there was a picture or the better there. Damn now why? The witness for Odo Broni Bejina that can be Sunday. Damn dan what about almost no hobby. No obey damn traditional wedding 2010. No so that no say back no so or say kaftan or say day now or describe your tara ubenya or say at the uniform. But the picture na bush paint bar there we try damn dan. No one say damn I full don't do a suit na day. Even that picture I'm coming to my point. Even that picture, Nesan, I was the kawa around Kawadisha, ye been kuna hadi, but because of that, what attending in Tina Nesan, wabedi oh, you know that me, the dam, for instance, Odo Broni and from the Prisla, they have honored the Abushapeni or the dam document in the Daba. He believed that is the original picture they took that very day. Right now, most Mravmo Pache, when Ubi Sabbath to Benasa, you don't object, the court presumed to be what? Genuine. There are plenty, like we see, or sort kind of there be picture of you to my day, or ye, because on there is a Photoshop. Because in fact, we understand that crampon is even different. So, in scenario like this, where I believe that the picture that I've submitted is genuine, and then my opponent is objecting that it is not genuine. How do you authenticate as a judge, as a court, that how do you know the authenticity of that picture? What are the picture of that band? The bottom there or your authenticity?
No. You see, judges don't make judgment in vain.
Okay.
No. No judge makes judgment in vain. Answer na judge, or be making a judgment, or share. It's on no observe procedure in court. Proceedings in court. It's on or share would demeanor, gestures in some America. Evidence said that no demeanor, no the boom. I feel or the atom and son one money judgment. Inti men court there a free day you could deceive a court. It doesn't work that way. Judge no or to one no or should be in some more no or that to them branded or that into the rich and true boom. The can no and they are trained to do that.
So here the situation I'm talking about here is that the marriage certificate itself now or objected the on your marriage certificate. But for the consular,
judge Nasa mind, it wasn't
authenticated.
That's all. It wasn't, and it wasn't.
But I wish maybe those that will be watching it, I will try my best to. The last time I posted the family book, you know, extractive film, I didn't. They pull it down because they felt like the other information don't need to go out. It's against their policy, so they pull down the video. But looking at authentication part, you have read. For this is the lawyer, the plaintiff, lawyer Nankasson was sending away the mom there. Also, best send even over 45 pages written statement response or the count adina or dama. Send a bear there or the demand authentic because I wonder there was some.
Mama Casa, some American Yamato. But the point is that outside the court, we don't speak law. It's in the law court that we speak law.
Okay.
Counsel for Plaintiff was sent BBA more to the American Nadi. Obetumi send them. That time in the other court.
Also, can court process court
intimidating a judge and still okay there.
And in means I was
sitting here, no one, I wasn't there.
Okay.
To see or to have seen what had been presented.
Because now the narrative out there, the lawyer of over 20 years experience at the bar.
Because
just common this process,
because we are all reading from the judgment.
Okay.
We are all reading from the judgment. I didn't go.
Because you are also reading from the judgment because ABR there's some other documents be why we are judging one can one say.
That is why he can. That is why
he can appeal. Okay.
That is why we have the processes of appeal. Intino counsel for plaintiff no free day. In your maybe one more the koi and no can judge no and consider. There is another opportunity.
So you have read the judgment, entire judgment. What the witness Nadine now was the bay. To the judge, the witness from the plaintiff, the respondents were all accurate.
One can't accurate. I'll say credible.
Credible.
It seemed to be credible.
It seems to be credible, which are a little bit presumptuous.
I do not understand what you are saying, but more kind there are some witnesses for the defendant. No, Sisido. Plaintiff no witnesses.
Okay.
And it can cross-examination more than so. Everybody will attest to it. There are some a counsel for defendants, witnesses for the defendant working. No, Sisido.
And people are having it very problematic.
How?
One thing there, and the judge needs me to chair the man. There's something I'm saying that me to chair the man. To the point where you can crampness will be jina, honest media guide, jina, over catching the media guide in ten of no point. So how she treated journalists in that room, top notch.
Exactly.
And lucky, the reason why there's an uproar of this judgment, I'm just giving you this.
There's no an uproar. I don't see any uproar.
A lot of people are saying that.
We had two opposing sides.
So there will be other people that will be objecting. Yes.
There will be people who will not be happy with it. That one, no doubt.
One thing I wonder, it seems to be credible. The word it seems to be credible, not kind. Fortunately for the public, some of the media guys which I happen to be there, were able to through the cross-examination away and doing our response. They were able to capture all of them. And even one person, sometimes after the court section, the media guys will come there.
Everything you want to capture. You are not the judge.
Yes. The reason I'm making them there. The cross-examination, the responses that what the man had done, it was well known to the public. And when I ever that man will be so as soon as he will be sent a response of the man ye okay, for nine A and B. All other responses I didn't know about. It's one kasa before that judgment because ordinarily the law and the demeanor and assembly can now boom to pronounce judgment. The responses for all the parties now is already in the public domain. And some of the responses one kasa quite for grandpa. They be mekande me court to catch him so Bible and I swear to tell the truth that they tell the facts.
You see, Mamenka, I've seen where you are going.
You could see that they be a small pakon ebia and still no kind of crampo ebia onya na kwa.
Yes.
But maybe a small ebia Georgina can be onya na kwa.
Say there was some cocotte. Say a winner, e bo hunde win. Enyim. You will see it.
Better than because
sometimes we also listen to comments from the judges from the court.
Yeah.
We also look at the demeanors of the court. We also look at some of the instructions of the court. It had was some court in the arena. We will lose to say boom.
Okay.
When you are losing, you know that you are losing. That's the truth. A lawyer need there was some court. Now in the process of cross-examination, re-examination, evidence in chief. When you are losing, you see you are losing.
Okay.
That one, no doubt about it.
So per your own analysis, now that they are taking the case to
the Court of Appeal.
Court of Appeal, a lot of legal brains are saying that it's a dead on arrival. It is this and that. It's this and that. From your own expert opinion, maybe I don't know if that one also sound prejudicial. I can't tell. But based on what you have read, I don't know what the lawyer for Akosua Serwaa have seen now. Nintos damn then all the appeal
well,
because there's
appeal is another way for
a redress.
No, rehearing.
Okay.
That way. And when you are going for an appeal, there are 3 things or 2 things involved. Either the judgment that has come will be maintained, or it will be modified. If I say modified, either advanced or reduced.
Okay.
With respect to what has come up.
Okay.
Very importantly, the evidence that you have adduced before the trial court is what will be used. If you want to adduce new evidence, 5 things are involved. 5 factors must be considered.
What are they?
Might be 1, unavailability of
the said evidence you want to adduce.
At the time
the trial
was ongoing, and
okay.
you made due diligence. On Sanka, sir, evidence. That's 1. 2, credibility. How credible is that evidence to the matter?
The matter.
3, impact. That because you didn't get that evidence,
judgment now anchored the other way.
This way,
okay.
But if you are getting that judgment, that evidence, you think that the judgment wouldn't have been like that.
Okay.
So the impact on it. Then the interest of justice. Say the court will consider it. Say, okay, for the interest of justice, you can adduce that new evidence. Are you getting what I'm saying?
Yeah.
So about 5 factors I've spoken about: credibility, impact, interest of justice, the unavailability,
the last one,
and basically, because actually I think 26 of CI 19, Court of Appeal rules, CI 19, it talks about those things briefly. So it's the right of counsel for the plaintiff to go and appeal. That is their right.
So in a situation where he wants to adduce fresh evidence,
I've spoken about
it. No, but the defendant,
mm-hmm.
Can they also oppose in any other way?
Why not?
So that's when they'll have to argue whether the court will admit or not.
They will also go and argue. They'll go and advance their argument, whether the court should admit it or not. And the Court of Appeal will sit on it and give their ruling. So they will come and oppose it.
This one, three judges.
Yes, the matter was tried at the High Court. So now they ascend to the Court of Appeal. That is what will happen.
Internal worries are from day one, was started counsel for the plaintiff on movie motion. We read everything to the last part, especially the cross examination.
I cannot preempt what will happen.
Okay, because I just want to know how it is done.
No, I will not want to state what the Court of Appeal. The Court of Appeal is an authorized body on its own.
Okay.
And I cannot dictate what or say to the media what will happen there.
Okay.
Anything can happen there. I can't say it here. That one I can assure you. I wouldn't want to say anything to that effect.
Okay.
All I know is about whether they can adduce fresh evidence. All what I want to say is whether they can adduce fresh evidence. And if they want to adduce fresh evidence, what should be the parameters? Again, it is their right to go for an appeal. But what I want to say here is that one, try the pressure na yedema lawyer Kusino.
So run the narrative out there, like we see no one in the
I don't agree to it. We have a lawyer Kusi for the plaintiff. I agree that lawyers take instructions. We act on instructions. At the time of the trial, at the time that the matter happened, the instruction that he might have had from his client, he acted on it. Having acted on it, at that time, if we say, he gave his expert advice and acted on whatever advice he had or instructions he had. Not that he's a bad lawyer. He's not a bad lawyer. Some doctors fail, lawyers as well fail sometimes. If somebody fails in a particular case, it doesn't make the person a bad lawyer. That is why he still has an opportunity to appeal. We cannot tell what the appeal will go, which direction it will go. We cannot tell. But the most important thing is that he is on top of his game. He knows what he's doing. Let us give him the opportunity to work for his client and let us see the outcome of it. But insulting him and some of the commentaries about him, it was social media and other platforms, they are very bad. I would advise that whatever has happened, one, Mepa Akosua Serwaa, that in my candid or honest opinion, Oma Yenjintu na Yama that Lumba Yankatanichi Fefe. Asamna Wabano, so Kodra Odinguasi or the Brebusia. That Lumba you be a Yenina Yedi Eniti Yedeman, Yedi Odo, Yedeman. Inti Yabese. There, for now, Yamada de Lumba needing under the yin seen fefe, Yankatanichi fefe. Say the argument is that on another the Lumba Wakoji is kebi a kabida ho mesre Ebusia Pinino is a capable person. Ontinum after say kabi honum no ye no kwade daddy Lumba no wako bakao baby. Utum woba Ebusia Pinina name. Now a kwaya yaba fada ye settle a cow honum. Itum ya settle. Embawo Ebusianum. That Lumba Ujamba, court is Ujamba 11.
Yeah.
It is her right to appeal. I will not dispute that. Now, so for the sake of the name of that Lumba, Mumai young Nyabutani and Katanichi. Now, assembly people for Yaman penny for in Tinum, na Yankasa. That, in my view, would be the best option. Now, until Odo Broni so mafu to Amidba Mande, Asamno. Court akenwe enidini ubu edodema ne that Lumba European or ye mama Akosua Serwaa on farman and match the time the other man on cordon farman na onka mama Akosua Serwaa ho na mbuo bi o de wode boa ma eyi no obado fefefe no mo mehi nyina ye. That is what I think should be done. But on your day ye be kodo na ye gudade Lumba na nyima ase na yakeka nsama on here na afuto so koma nya na ye wa mama na abrochi ana amanane a ye gu court no hu fi
ye kobra
ye ka court ho asam judge no ye we are insulting the judge. We should desist from it. Nya na so ye Ghana courts are very credible. We are the judiciary now is a very solid one. It's in one hour abrochi a said the work can send be brief for judge no one or ye attempted DNA on fatan.
And not to justify whatever I don't insult. I don't know how to even do that. The reason why most of them are more express what frustration in the because especially when I was Germany in the US now, I didn't have when you have marriage certificate at the city. When you the certificate not the ban. That is original about authentication. Means I'm for catching maybe say just normal authentication to be a lawyer because you went to 1 year and in time went to 1 day 1 week case. Atasi
matters.
In time most of them are
case moti be any pakor be mini ni pakor belusi. But there is peace asombiaba. Judgment naba. Mubia de court anti say what the court the court in demand there is judgment. Mesre anti sewa. Oma imida ye woma that Lumba yan kodena yan farmer na yan katanichi fefe na yɛn fo wo from yɛn so a yɛawɔ where wa manana yɛwɔ similar situation mono let us take the rightful steps na yɛn rectify those errors ma futu ne moma dadule on the 13th yɛn katanichi fe man kasa mu nia na my brother Papa Shi no so mori ya no
so
Papa Shi evangelist mama kan de on mana kumambrefom kra because at the end of the day you know me yatiti nyanye de on kebusia no and in fact under the circumstances the busia penyin can injunct him moral kodo no so kodo ye busia penyin can through his counsel can injunct him there for the court to restrain him from making comment about that lumba or the funeral or anything. But yebeshe Morocco do media no he is demonstrating in clear way say onye that lumba ewo asem unresolved matters, unresolved dispute, unresolved problems and untreyi mesre most of Papa Shi evangelist yes no we si bia no onjinem as a man na o make sure the asomdwe abebusia no wante nyame show bia
lawyer BKE our friend Bernard Kofi Assibuah ya fan the phone or the broflo for the China or the film on this year we're breaking it down my agent there more share supim I want to take this opportunity to say thank you for watching this exclusive interview. It's been almost an hour interview. I believe that much it's a film. What from Isaac Dazi, we still continue to talk to. I mean, what's a lawyer for the young saying back for it, and I believe that he has done justice to the case now. I will come away some other time, but they are going to have an exclusive interview with him again, but on a different matter. I believe that matter. You guys are, you know, the toughest lawyer that I know. Hey, Charlie, oh, you put the tweet in us in the chair. I hope I'm one. Okay, that's it. All right, thank you very much for watching.